Rondell M. Mershon, X-Rail, Highland M. et al. Versus HPT TA Properties Trust et al.
Good afternoon.
Good afternoon. May it please the court, Colin Calhoun of the Nashville Bar. I represent the plaintiffs and appellants in this case. Ms. Melba Mershon, she's the surviving spouse of Rondell Mershon, and also represent her minor children in this wrongful death case arising out of a sport utility vehicle versus motorcycle collision. If I may, I would like to reserve 4 minutes for rebuttal.
4 minutes, certainly.
Here, the central issue turns on the issue of duty regarding the TA defendants, HPT Properties Trust, and TA Operating LLC Travel Centers of America. Of course, this motor vehicle collision occurred on an adjacent roadway to the private driveway road of the TA Travel Centers in Franklin on October 6, 2016. The core allegation of the plaintiffs in this case is that the TA defendants failed to clearly place prominent signage identifying the separate points of ingress and egress to the Travel Centers of America. There are two. Driveway number 2 is for truck drivers, commercial vehicles, and driveway 2, a little over 300 feet northbound, is for passenger vehicles. And of course, this is the second version of Mershon. It's been up on appeal previously, as you all may recall. Now the case is presented to the court based on the trial court's denial of the grant of summary judgment. The trial court arrived at its decision to grant summary judgment in this case concerning the issue of duty, as well as causation and proximate cause, primarily as a result of not considering the declaration testimony of the plaintiff's retained transportation engineering expert in this case, Dr. Robert Stammer. Dr. Stammer reviewed and considered a substantial amount of data and materials informing his opinions and conclusions, including the City of Franklin's investigative file and cert report. And that file included written statements of Kenneth Page and Gail Page. Mr. Page made a left turn on Long Lane from the center turn lane, and in doing so, Mr. Mershon, who was heading southbound on Long Lane on the way to work, crashed into the passenger side of Mr. Page's sport utility vehicle. And Dr. Stammer was hired to do a forensic investigation into the cause of this wreck. I respectfully submit that it's not just a simple wreck where Mr. Page did not see Mr. Mershon for just no good reason. He submitted a written statement to the City of Franklin Police Department after the crash occurred, and he described his actions. He described bringing his vehicle to a stop, and he looked straight ahead. He did not see any oncoming traffic coming at him southbound. He then looked to the left. Again, this is the driveway number 2 that's intended for truck drivers, commercial vehicles. He looked to the left, and he saw a commercial vehicle there. And then again, he took another look straight ahead, and he did not see any vehicles according to him, and he went ahead and negotiated that left turn. So this is not a case where there's any evidence that he just whiffed it, he just drove through there, didn't stop. He made an attempt to carefully observed what was ahead of him before he made that turn. So the issue is, were there other factors based on the principles and science of transportation engineering that contributed to this fatal collision, or that caused it or contributed to cause it? And Dr. Stammer concluded that there were other factors that contributed to cause or caused the collision. And at issue is a sign that was about 100 feet west of the relocated long lane here in this case. The experts in this case do not dispute that that sign was not in the field of vision of motorists. And that sign was intended to direct and guide motorists to the proper entrance. The entrance is. And the one that...
But let me ask, was there anything about the truck entrance that made access by a passenger vehicle inappropriate, physically, engineeringly inappropriate? I understand the two entrances are about the same. They both go to the truck stop facility. One was designated for trucks, but that was to maneuver the trucks into one area of the parking lot. But what was there anything about the physical components of the entrance that prevented a car from safely pulling in there?
It's the opinion of the Dr. Stammer that that was an unsafe and dangerous intersection there, long lane in the private driveway road to the truck stop. And it's his opinion.
And that was based on line of sight, if I understand.
Right. There's a dispute between the experts about the issue of sight distance. Mm-hmm. The expert of the TA defendants has the opinion that there was sufficient sight distance such that a turn could be safely negotiated from that turn lane.
But it sounds like you're describing a city duty here, not a TA duty.
I'm also describing a TA duty because that intersection existed because of the presence of the Travel Centers of America there, and they did have a sign that was intended to direct and guide motorists to the correct entrance. And they certainly should have known about the dangerous condition of the intersection there. According to Dr. Stammer, it's his opinion that there was limited sight distance due to the crest of a hill on the roadway ahead. In short, his opinion is that the sight distance for it to be safe would need to be 353 feet. And it's the opinion of the TA defendants expert, Alan Parham, who's also an engineer, that it should have been 335 feet. And Dr. Stammer goes into great detail talking about the environmental factors in the area that could be confusing to a motorist in that center turn lane as they are negotiating that turn, including the visually cluttered black background with the Williamson County Agricultural Center ahead, the limited sight visibility for oncoming traffic traveling southbound, the confusing aspect for a driver making that left turn that they can't see a sign specifically identifying whether they're turning into the right place. And it's his opinion that had that sign been located closer to the road, Mr. Page more likely than not would have recognized that this is not the correct entrance. I need to go down to the one at the bottom of the hill to turn in here.
Now, the trial court disqualified your expert, finding his opinions, or part of his opinion, untrustworthy. And part of that was based upon Dr. Stammer, your expert, stating that Mr. Page, the driver of the car, was confused. But the only evidence available to Dr. Stammer was the police report and Mrs. Page's testimony, and nowhere in either is there anything that would suggest Mr. Page was confused. So how do we provide a factual basis for your expert's opinion that the accident was caused in principal part because Mr. Page was confused.
Dr. Stammer arrived at that opinion based on the fact that Mr. Page, in his written statement to the Franklin Police Department, he described his actions with respect to what he did in that moment before making that turn.
And he said, I looked straight ahead, I looked to the left, and I saw a vehicle was preparing to exit, but it didn't impede his entrance, and then he looked ahead again, and not seeing any vehicle, he turned left.
That's correct. But due to the dangerous...
I don't sense any confusion in that.
But the factual content of his statement describes additional steps that he took. Instead of just turning after stopping, looking straight ahead, not seeing anything, he went through an additional process of looking to the left again. He didn't see any sign. He also saw a commercial vehicle turning out of it. And what he talks about in his testimony is, based on the evidence available to him in determining the cause of the collision, he described the concepts of perception reaction time and perception intellection, emotion, and volition time as key factors that resulted in delayed reaction on his part. That the delayed reaction based on the stimuli available to him at that time resulted in a delayed turn from that intersection.
All right, thank you. You'll have more time on rebuttal.
Thank you, Your Honor.
Mr. Calhoun. We'll hear from the appellees, and will more than one of you argue?
Just me.
Just you?
Just
Well,
me.
Then you've got 15 minutes.
May it please the court, Jessica Barger, and I'm here for the TA defendants. I'll refer to all the defendants as TA.
All right.
Counsel does discuss that this case dealt with duty, and the court found no legal duty because there was no evidence of foreseeability, which is a correct ruling. But this court also went through an analysis and found that there was no cause and fact or proximate cause at the end of the opinion. That is critical here because appellant didn't raise any challenge to cause and fact or proximate cause in their opening brief at all. In fact, it's not in the brief in any way, not in the issues or the body, until we raise it in our appellee brief and they come back and discuss causation, cause and fact, and proximate cause, which this court knows are two distinct elements of their causation claim. In the Lovelace versus Baptist Memorial Hospital case, 2020 Westlaw 260295, it's very analogous there. There, the trial court granted summary judgment on independent grounds, and two of the independent grounds were duty and causation. The Court of Appeals then held she only raised one ground on appeal, and causation was not designated as an issue or briefed because she failed to properly challenge one of the two independent bases. The trial court granted summary judgment. The trial court's decision on this matter must be affirmed. As this court knows, in Tennessee, Rule 27, when you fail to brief an issue, you can't use your reply to correct deficiencies in a brief, and this is well established in multiple Tennessee Court of Appeals cases, as well as the Tennessee Supreme Court, which has held it is not the role of the court's trial or appellate to research or develop an argument, but he should have raised causation. So I think this court could affirm this trial court's summary judgment on that basis alone.
On which ground?
On the causation.
Okay.
Because causation was not raised, cause or fact or proximate cause.
So your position is the appellant is only challenging the duty finding?
That is correct.
Okay.
Causation was not, which is a critical element of their negligence claim or premises liability claim, was not raised until pages 18 through 20 of their reply brief.
If we get to the issues here, I'm interested to know if it's TA's position that for entrance number 2 at this truck stop, passenger vehicles were prohibited from entering that entrance of the truck stop.
Are you asking were they prohibited, or is there any evidence in the record that, what were they prohibited? There's no evidence in the record that they were prohibited for entering that. There is no evidence in the record. In fact, the only evidence in the record is TA Travel Center's interrogatory responses, the 2 competing affidavits, and then the parties' statements of material facts. So there is no evidence in the record that basically says we're prohibiting, or passenger vehicles can't use that entrance. It was just there. There is also no evidence in the record that we had any notice that it was a dangerous condition or would have been a dangerous condition. In fact, the only evidence in the record is interrogatories 8, 15, and 16, which say that TA Travel Centers didn't have any notice of any other incidents or lawsuits or anything about that intersection. And as this court already has noted, there isn't any evidence to surmise or guess or infer that Mr. Page was confused. In fact, there isn't even the written actual statement or the police report in the record. It's just based through the affidavits.
Is there anything in this record about whether or not the signage that was present met code requirements?
So our affidavit, Mr. Parnham's affidavit, does discuss specifically that the code requirements, and I can tell you the site for that is 241 of the clerk's record, and then basically talks several pages, paragraphs 27 through 36 of the affidavit talk about how there was no evidence that they were not in violation of anything with the Tennessee Department of Transportation, or there was something wrong with the signage, or they should have done something different. And they weren't even on any notice to do anything different. So I think that the trial court here reached the right result in 2 ways, on duty and on causation. And I think the trial court actually applied the correct standard of review. They are taking issue with the trial court standard of review. I think the trial court properly applied the standard of review under summary judgment. And I think that the case that they rely on, Martin versus Norfolk, in that case, summary judgment was improper, but in that case, we should note that the plaintiff brought forth not just a deposition of the experts, but eyewitnesses and other things to create a fact issue. Here, there isn't anything to create a fact issue or to show that there is some sort of duty, or some sort of duty should have been imposed on TA Travel Centers. I think that the Green versus Green case out of the Supreme Court, which really talks about not all factual disputes require the denial of a summary judgment, and many disputes are minor or not germane. I think if this court looks at the evidence in this record and considers what the trial court did in several pages of his order, essentially going through bit by bit with the affidavit, I think the court also did the right thing with the affidavit. I think this court can look at the court's decision in disregarding, well, not just disregarding, considering the affidavit and then disregarding the statements because they were not based on trustworthy facts. The trial court was correct in the final sentence of its order, where it cites specifically Tennessee Rule 703. The court shall disallow testimony in the form of an opinion or inference if the underlying facts indicate a lack of trustworthiness. I think Dr. Stammer here, that's exactly what he did. He took facts or statements from Mr. Page that he got from the report and then surmised or guessed. And this isn't about weighing the credibility of the 2 experts. This is about guesses and speculation. And I think that the plaintiff's case, which is Briggs versus Town of Nolanville, where they say that this court should consider that case, the court there actually noted, or the Court of Appeals there actually noted, that the trial court didn't even consider the plaintiff's evidence. Here, it is clear that this trial court did a very thoughtful analysis. And of course, the court knows the proceedings and the procedural history of this case.
Is there any evidence in the record that entrance number 2, I think that's the right number, of the trucks?
The truck, yes, Your Honor.
Was presented a danger or a hazard if accessed by a passenger vehicle?
There is nothing in the record. In fact, I think this
Was
court,
there any signage that said no passenger vehicle?
there's nothing that says no passenger vehicles. There was no evidence that TA centers had any awareness that this intersection was a dangerous intersection or that they should have done something different. In fact, I think this is very analogous not to the DeArt case that the plaintiffs rely on, because I don't disagree that there are maybe some circumstances where an abutting or an adjacent property owner might have a duty if they create or cause a condition, like an excavation in that case where the subcontractor specifically left a hole and didn't put barricades around it. I think this case is more analogous, and I think this court could follow the Howell case and the Estes case. I think the Howell case is a very good case for the very reason that the plaintiffs argue that you shouldn't follow the Howell case because there was no expert proof supporting the theory of liability. But here, I don't think Dr. Stammer's affidavit gets them there, and I think the trial court made the right decision. And also in the Howell case, it states to evaluate the duty of care involves the balancing of the foreseeability and gravity of potential harm and preventing that harm. The court then found that there was no unreasonably dangerous condition on the property and nothing was foreseeable, and it wasn't foreseeable, and it wasn't foreseeable there, and it isn't foreseeable here that to TA that somebody would have failed to yield the right of way. And
Let me ask you, in connection with construction of the entrance to TA, did they have to have approval from either the state or the city or county for the location of the entrances into TA?
Your Honor, that's not in the record. I mean, do they have to have approval to where they put the sign or where?
No, where they erected the entrance.
I actually have no idea. I have no idea. That is not in the record.
Okay.
I have wondered the same thing myself, but this record, the problem in here, the record is very absent of a lot of evidence and a lot of facts. There were no other depositions taken, there were no witness statements, and there's no other discovery even for this court to consider. So I think.
So there's no proof in the record that they constructed the entrances in a location that was not approved by either the state or the county?
Well, Mr. Parnham's affidavit, which specifically states that there is no evidence that they did not violate, there's no evidence that they violated or they did something wrong, or they didn't follow something that the Tennessee state, no, they've never been cited for anything. There was nothing, I don't think that there's anything wrong, or they were not in violation, and that was also part of the affidavit of our expert. And I think to impose any sort of other burden on a property owner essentially would create, as the Tennessee court said, to hold otherwise being an onerous burden on every property owner. They also argue that we should have done more, or we should have had a different sign, but I think that also goes to that they have to show that there would have been something dangerous about this intersection, and this wasn't just the fact that there was a failure to yield the right-of-way. I think in the Estes case is very analogous, where they took the balancing test there, that imposing a duty on a property owner to prevent a driver from pulling out on a highway without yielding to oncoming traffic would be an owner's burden. I think that if the court looks at the cases that the trial court did and the very clear analysis in disregarding Dr. Stammer's affidavit, the plaintiffs did not satisfy their standard, and I think the court here specifically applied the correct standard of review, and this is why summary judgment is proper if the moving party submits affirmative evidence that negates at least one essential element of the non-moving party, or we demonstrate that the non-moving party's evidence is insufficient to establish at least an element of the non-moving claim. Not only could this court affirm on waiver because they failed to raise proximate cause and cause in fact at all until their reply brief, this court could affirm because the trial court reached the right result on duty and causation. So we ask this court to affirm TA Travel Center's motion for summary judgment.
All right. Thank you, Ms. Barger. Mr. Calhoun, your rebuttal. Would you address her argument about the trial court found 2 grounds upon which to grant summary judgment, and that the defendants are arguing that you only took issue with 1 ground?
Sure. I respectfully disagree with the position of the TA defendants in that respect. The trial court stated there's no evidence in the record before this court that the TA defendants owed a duty of care to the plaintiffs, nor any evidence that any act or omission of the TA defendants constituted either a cause in fact or proximate cause of the plaintiff's injuries. That was the extent of the trial court's analysis on that issue. But in the brief that I submitted on behalf of the appellants in this case, the issue of causation, cause in fact, and proximate cause is discussed in detail, bottom of page 44 of the brief, all the way up to the conclusion regarding the opinions of Dr. Stammer that support the notion that there is sufficient evidence here to support a finding of causation, but for causation and proximate cause, which are jury questions. So I respectfully disagree that it was not discussed in the brief. It was discussed at length. His opinions that support the facts in that regard. With respect to the issue of notice, I think the law is well settled that if a defendant creates the hazardous condition, it's not necessary to demonstrate prior notice. It's also important to consider this is a very compressed time frame as well. This relocated Long Lane project, I think, started in 2013, and there was a letter that was submitted by Weller Corporation to the TA defendants in January of 2015 that gave the TA defendants, and this is an undisputed fact in this case, the experts agree on it, the TA defendants were notified that the city of Franklin had authorized the TA defendants to move this remote and misplaced sign much closer to the road where it would have been visible. This was in January of 2015. So they knew more than...
So I'm having a hard time conceiving how you frame this duty in this case. Is it a duty on a landowner to always have signage that is visible from a public roadway? Is that the duty?
It is here because there's a dangerous intersection, and the experts
But that same intersection is being used by commercial vehicles.
But that's why it's important for passenger vehicles not to use the commercial entrance, because that intersection is dangerous for a passenger vehicle to make that left turn and not go down to the bottom of that hill where the entrance is for the passenger vehicles.
What makes it more dangerous for a passenger vehicle versus a commercial vehicle?
There is limited sight visibility for a motorist who is in a passenger vehicle in that center turn lane making the left turn. And according to Dr. Stammer, he explains in great detail why that's dangerous in his declaration, and it's discussed in detail in the brief. But the sight distance, according to Dr. Stammer, appropriate sight distance for that intersection is 353 feet, whereas the defendant's expert opines that it's 335 feet. And he describes certain other environmental factors that are at play in regarding that intersection too, that can cause a driver to experience confusion when making that left turn. But in short, there are disputed issues of material fact that preclude summary judgment. The trial court erred in disregarding the testimony of Dr. Stammer. An expert is certainly permitted to review and consider testimony that's not admissible evidence in formulating their opinions and conclusions, and that's exactly what he did here in doing the work of an expert witness. I think that concludes my time. Absent any questions, I'll step down.
Hearing none, thank you, Mr. Calhoun, and thank you, Ms. Barger, for your arguments. We will take this matter under advisement.